What is the status of the virtual zone person, and what are some tax benefits that companies can receive with the status? A new precondition of the revenue service is added to the legislation. Our reporter Gela Barshovi spoke to the expert in tax issues, Gela Barshovi, in a one-to-one interview in Forbes, Georgia studio. Here's the update.
Hello Gela, how are you?
Hello Shata, I'm good, how are you?
Thank you, I'm fine. Gela, please tell us about the status of the virtual zone person in Georgia. Who can receive this status and what tax deductions and benefits they can receive with this status?
Yes, virtual zone person is a status applicable for IT companies in Georgia. If an IT company applies for a status of virtual zone person, they receive a special certificate. And if they satisfy certain criteria, they can enjoy tax exemption, in particular corporate income tax exemption. So the important preconditions are the following. IT company shall be providing services abroad, and they shall be creating IT's definition of IT is an activity as a result of which software product is created. So to say it simply, in simpler words, virtual zone persons are exempted from corporate income tax on income from software development services provided abroad. But newly, another precondition was added by Georgian tax authorities under the new approach, and according to this approach, they require to have sufficient business substance in Georgia so as to qualify under such exemption.
So you have mentioned the new approach from the Revenue Service of Georgia towards the virtual zone persons. Can you tell us more about this?
Yes, so according to the new approach of Georgian tax authorities about taxation of virtual zone persons, the software developed and provided by virtual zone persons should be developed in the territory of Georgia. It means that the sufficient business substance should have a virtual zone person so that they can qualify under the exemption. Just to overview the history of legislation about virtual zone person, there is in the end of 2010 law on information technology zones were published. And the Article 6 of this law says something similar, the following, that virtual zone person is supposed to create ITs in the territory of Georgia. So by the way, it should be noted that Georgian version of a law is a bit different when the English version published on Matsne.gov. So I advise to rely on the Georgian version, which is the original one. So this law mentions the wording territory of Georgia. So this wording was relied by Georgian tax authorities to interpret the legislation different way. But in fact, this law is not only one determining the taxation of a virtual zone person. There is the tax code, and which is main legislation, and it's prevailing legislation according to the hierarchy of the laws. And the Georgian tax code has 3 paragraphs in total about taxation of virtual zone person, and no wording, nothing is mentioned about precondition as a developing in the Georgian territory or any substance, etc. So just to overview what I already explained, so that there is one wording in the law on information technology zones, but this law also, another article, says that taxation of virtual zone persons should be determined by the Georgian tax code. And if we go to Georgian tax code, which is referred by this law, there is nothing mentioned about development in the territory of Georgia or having business substance as a precondition for exemption. So in addition, if we ever say that, okay, this is correct and there is law says there was a precondition, it is not explained what does it mean that a software is created in the territory of Georgia. Virtual zone person is a legal entity, which is and a resident legal entity based on its registration criteria. And this legal entity is absolutely independent from an individual. So if a software is created and provided on the name of a legal entity registered in Georgia, why it should not be enough to consider that this software was developed in the territory of Georgia? There are those questions, other questions, and just in general, I understand the logic of the tax authorities. They want to provide exemption to not to letterbox company, but a company with sufficient business substance who brings some benefits, which brings some benefit to the country. But one is the logic, another is what is written in the law, because law should supplement fit the logic, what I already mentioned. The law does not request such a precondition, and notably during 10 years, there was no any tax assessment on this case, which brought some understanding in the taxpayers that the tax authority of Georgia thinks the same way. They don't request to have business substance. So after 10 years, they just immediately faced the reality, surprised that they have to pay taxes retrospectively, which is the biggest problem. So they were asked by tax authority to pay tax from 2018, 19, 20, 21. So what I think the solution of this case might be that the new legislation is changed, or new guideline is published, and from this time, from a current time, the new approach is applicable, but not from a past period when tax authorities, taxpayers did not have any idea of such requirement.
So as a tax expert, so what would be your recommendations be towards the virtual zone persons who are operating in Georgia?
Yes, I would say the past period is more arguable because there was no any information available for taxpayers, but now everyone knows what is the opinion of the tax authorities. So if they do not create enough substance, it's higher risk that there will be still tax assessment. So I would advise to think of creating new business substance in Georgia, or advise apply for a tax ruling which would give them criteria of what is needed for them to satisfy, to enjoy the exemption, or at least until everything is clear, I would not advise to enjoy the exemption with no any substance in Georgia, because when we think it's correct, now everyone knows that opinion of a tax authority, which is quite straightforward, is that they do not provide exemption to letterbox companies anymore.
So what do you think will the mentioned new approach from the Revenue Service can have a negative impact on Georgia's reputation on investment destination?
Yes, I think it will have a negative effect, and I also know that from the feedbacks I receive from virtual zone person founders, which are my clients or who I just know personally. And the main problem is not that they don't understand the logic. They understand the logic, but they know that the tax law gave them possibility, and after tax authorities tells them different what is written in the law, in their opinion. So biggest problem is that the surprise, lack of information they had. If I would knew before, right, from the beginning that they are required to have enough business substance, to have higher staff, etc., they would have a right to decide whether to come to Georgia, make business substance and continue operations or not, right? They did not have this right. They thought everything is right. They thought they were following the law, and they faced two surprise, right, two consequences that they did not expect. So that makes feeling of instability for them. And this instability is the main factor which probably drives them to leave a country. I think this for sure negatively will affect to investment environment in Georgia.
Thank you, Gela, for your answers.
Thank you, Georgian.